Welcome to the Migrant Center for Human Rights DreamWeek podcast series on advocating for equality and justice for immigrants under the Biden administration. My name is Sarah Ramey, and I am an immigration attorney and the executive director at the Migrant Center for Human Rights, where we provide free and low-cost legal services to immigrants at the South Texas Detention Complex in Pearsall, Texas. We present this program to you today on the cusp of a new administration, a few hours before Joseph Biden is sworn in as president, as a call to incoming President Biden and Congress to not forget the plight of immigrants in detention, whom have not been included in the three main prongs of Biden's current forthcoming immigration bill, and to ensure that justice is protected in our immigration system. Today's conversation will focus on detention policy. A list of topics to be discussed is in the description box. If you missed our podcast on asylum policy or border policy, you can find the recording on our YouTube channel. We also encourage you to tune in to the other two podcast series later this week, each at 8:30 in the morning Central Standard Time. More information will be provided at the end of today's podcast. The topics we discuss today are intended to provide an overview of problems that we believe need to be addressed as soon as possible. It is our hope that the information provided today will serve as a springboard for brainstorming ideas on how you can help ensure our immigration law and practice align with our American values. We begin our presentation today discussing the danger that immigrants face in detention. Currently, there are approximately 15,000 people detained nationwide. Unfortunately, medical care is often insufficient. Providers will prescribe ibuprofen or another form of painkiller, drinking water, and resting as cures to almost any ailment. It goes without saying that individuals are not given a choice of provider and must content themselves with whoever the government provides. We have also seen issues where individuals are treated by nurses and not by doctors themselves. There are cases of extreme abuse, neglect, and incompetence. The level of psychological care is often also severely lacking. Even where care is provided to the best of the doctors' and nurses' ability, the fact remains that it's very difficult to recover or heal many ailments in a detention facility. Whether the individual is suffering some form of physical difficulty or sickness, or whether the individual is suffering some form of psychological disease such as PTSD, severe depression, anxiety, being in a prison environment does not give them the safety and the rest that they need in order to heal appropriately. It is for this reason, as well as many others that we will be going into throughout the course of this presentation, that detention needs to be limited in every case it possibly can be. There are many advocates that call straight out for an end to all detention because of this problem and many others. Currently, most recent data has shown that close to 9,000 people have tested positive for COVID. So far, there have been 8 deaths due to COVID in ICE detention facilities. This is due to a variety of factors. Among those, social distancing can be difficult. The provision of masks and sanitation equipment, such as hand sanitizer and soap, has also been spotty over the last half a year to close to a year. There is an issue with testing people and quarantining them in a way that prevents the spread of COVID from one place to another. And this includes the fact that ICE has transferred individuals at facilities that have COVID into facilities that do not have COVID, and has contributed to the spread of the virus as a result. There is an issue that we've seen repetitively at the Pearsall Detention Center where, due to quarantine, individuals will have their court cases canceled. In some cases, this has happened 3 or 4 times, prolonging their detention for an additional month or 2. Individuals have been getting increasingly frustrated with this process and, are wanting to proceed and resolve their cases as soon as possible, and to get out of the detention center where they feel incredibly nervous and stressed about the risk that they face. This is both for individuals who are particularly medically vulnerable for reasons of pre-existing conditions or due to age, but it is also true for everybody that we've spoken with. ICE has said that they will provide vaccines to everyone at the facility, but it is unclear when that will happen or how the cases will be prioritized. If they'll start with one detention center first and vaccinate everyone there and then move on to the next, or if they're going to review medical records and base the vaccination priorities on an individual's particular circumstances. It's also unclear if individuals have a choice on whether or not they want to receive the vaccination. I suspect that it's unlikely due to the fact that in the past, with outbreaks of mumps, individuals have been forcibly vaccinated. So, there are potential issues around that as well. There has been litigation begun from the beginning of the COVID pandemic to release medically vulnerable individuals. And the largest case, which is a national class action, is Frahat. That case basically says that ICE needs to review all the medical files and make a determination on whether that person falls within one of the categories and should be considered for release. Unfortunately, while this litigation has been very helpful in getting ICE to pay closer attention to some of the cases, ICE's decision-making is still in their hands. The court has not ordered them in any particular cases to release an individual. So they still have discretion on whether they're inclined to grant that release. First off, it's worth mentioning that non-risk cases are still being detained and are not being viewed as in need of release, even though COVID is much more likely to be contracted in a detention facility. So there is a COVID release argument even for those who are not, quote unquote, at special risk. But ICE is basically operating per usual. Their modus operandi has not significantly changed with regards to release policy. They initially did release about 700 people around the time of the court decision in Frahat. So this initial sort of push to decrease numbers in detention was sort of the end of April, beginning May, and that has contributed to more space and social distancing, but a significant amount of the lower numbers that we're seeing today as opposed to a year ago when we were looking at over 50,000 people in detention is really a result of CBP's Operation Capio, which we discussed in the podcast on border policy. That video is available on our YouTube channel. We encourage people to check it out. But basically, that's the policy that says, due to COVID, we're not going to let anybody in. And over 200,000 people have been returned at the border as a result of that policy. So we're simply not taking people into detention centers in the first place. The lower numbers are not a result of increased releases by and large. The executive office through DHS, so through CBP and ICE, is basically still prioritizing deportation over release and is following all of the sort of standard policies which in many ways are actually more practices than policies that we'll be discussing on the next slide. The release policy must change. There are a number of different detention situations. Unaccompanied minors fall under the jurisdiction of Health and Human Services and the Office of Refugee Resettlement. Family detention cases are in CBP and ICE custody, but at different facilities due to the Flores settlement, which applies to accompanied minors as well as unaccompanied. And then there is adult detention. We'll be focusing on adult detention. That's of single women and single men. And these issues that we'll be discussing, by and large, are some of the most problematic issues in policy with regards to detention that, unfortunately, in many cases, have not received widespread attention. So first off, individuals who are in expedited removal, and we'll be discussing that a little bit later on in the podcast. So these are individuals who are recent arrivals in the United States. Until they pass a credible fear or reasonable fear interview, have not established that they have a significant possibility of winning protection, and therefore ICE has a policy to not release them. There are individuals, unfortunately, who are never given a credible fear or reasonable fear interview, sometimes out of no logical explanation, but sometimes it's because there's no interpreter available. So people from certain countries who speak certain languages are more likely to get passed through this process. This can speed up the process occasionally for folks. It also can eliminate potential problems in the future because the notes typed up from these interviews can often be problematic at litigation. And a full discussion of that is outside the scope of this presentation, but is certainly, a piece of this that needs to be considered in making sure that these screening interviews are conducted fairly and that the results are prepared in an accurate way so that there's no confusion later on in the process. For example, one of our clients was denied release because he never had the interview due to the language he spoke, and as a result of this, he was basically kept in detention for over 3 years. He was just recently released, and it goes without saying that the emotional hardship and stress that he was under was extreme. He went on hunger strike a couple of times, and he started feeling suicidal because he felt like he was basically just dying in detention with no chance of getting out. So the policy here really is not particularly humane, and it's not particularly in line with the U.S. Constitution. Our Constitution that says that every person, immigration status is irrelevant, every person in the United States has the right to liberty and can only have that liberty taken away through due process of law, meaning that there has to be a justification that's valid to lock someone up. And we see over and over again that this does not play out and does not hold true in practice. We've also seen individuals repeatedly be denied release if they don't have a sponsor, but more common because eventually, individuals without family or friends willing to sponsor them will get in contact with an immigrant shelter and will get a placement letter from them. So eventually people will get a sponsor, but there can be a delay, and occasionally, it can be a month or longer that extends the time that they're in detention. The problem that we've seen recently is that individuals, even when they have a letter of support from a well-recognized and reliable immigrant shelter, will be refused their release. And we are not seeing this so much with ICE, but we do see this with the judges. Part of this is because the Board of Immigration Appeals has issued at least one, and I believe there's been some subsequent decisions as well that have been unfavorable in this regard. Individuals who are asking for release from detention have to prove their identity, that they have a stable place to live, that they're not a danger to the community, and that they're not a flight risk. And this line of recent, just in the last year, BIA case law, as well as the way that some judges view these cases, basically has concluded somehow that an individual is a flight risk if they do not have community ties. So if they don't have family or friends, then they're not going to be interested in staying legally in the United States, and so they're not going to show up to their immigration court hearings. It's certainly true that if individual does have close community ties, they are going to feel more encouraged to seek out legal status. But the reverse is not. Right? We work with many asylum seekers who are desperate. In fact, they're so desperate to find protection in the United States that they have come to a place where they don't know anybody because they feel like that's the only option that they have. So what this basically does is it means that individuals who are poor and not well connected are forced to remain in detention. And we just had a hearing on a case exactly like this that was denied, despite the fact that this individual is suffering recurring nightmares related to the fact that of the torture he suffered in his home country is being sort of re-triggered by being in a detention context. But the judge, didn't really feel that that was a relevant factor in his analysis. So, this is problematic, and this is one of the areas with regards to detention policy where the Attorney General can step in. And so we are calling on Mayor Eric Garland to change this decision, and certify it to himself, change it, and be very clear on setting the law with regards to individuals' rights to live in freedom while they are pursuing their immigration case. Now, arriving aliens who are in the asylum process are not eligible for a bond hearing. So they're relying on ICE to release them, and there are problems with that. It's very important to have the judicial checks and balances of a judge hearing a case. And so an arriving alien is an individual who's presented themselves at a port of entry. So typically that's someone coming to our southern border, to one of the international bridges and saying, "Hi, I need protection." Right? So this has become less common as people learn about MPP, as people have been affected by the various policies that the Trump administration has put out that have effectively sort of forced more and more people to take the more dangerous route across the river or through the desert. And the Trump administration attempted to expand the policy to individuals who enter without inspection, such that regardless of how you come into the United States, you are never, as an asylum seeker, eligible for a bond hearing before an immigration judge. Luckily, that rule, or rather proposed rule, has been halted by the courts. There's also mandatory detention under IRA, which has a list of categories that basically mean the judge has no authority to release someone. And ICE has no authority to release someone. It doesn't matter what the facts of the individual's case are. Per se, you're done. And there have been a lot of there are organizations and advocates calling for a revision of this part of the law. In a typical case, this is similar to like a mandatory minimum sentence, right? In a typical situation, right, we want to have the judges have as much discretion as possible to respond to the facts and the situation of the person before them. And so mandatory detention really doesn't do that, and it has had some significant harmful effects on individuals and their families that really necessitates careful revision of this part of the statute. Individuals whose cases are on appeal to the Board of Immigration Appeals typically are not released, and those with final orders of removal. So that's either when the Board of Immigration Appeals has denied the case, whether or not it's appealed to the circuit courts, or it's when an individual was denied by an immigration judge and chose not to appeal, perhaps because they simply were worn out by being in detention. And the judges have begun in the last couple years to tell people that they'll be in detention, another 4 or 6 months if they appeal, which is true. And the judges did wisen up fairly quickly and now say, I don't mean to say this to discourage you, but it does have that effect. And individuals, even when the judges don't say that, certainly are looking at the time they're spending in detention. And, we try to tell them the same realistic number because it is part of the consideration they need to take. So we've had a number of clients who have decided to be deported and then flee to another country. They see that as sort of their best option. The issue to consider here is that every 90 days after a final order removal, ICE is supposed to review the person's detention and determine whether or not they really need to stay in detention. Basically, is it reasonably foreseeable that in the near future they're going to be able to remove this person? Because if it's going to take them another 6 months to deport this person, then it's really not justified to keep them in detention during that time. They would be released on order of supervision, potentially with an ankle monitor, but probably most definitely with check-in appointments. And eventually ICE would make arrangements for their removal, and then they would need to comply with that, or they would be considered an alien fugitive. The Supreme Court has basically established a 180-day rule that if the individual is still in detention, it's now presumed to be unreasonable unless ICE proves otherwise. And this, of course, is only applicable if the individual has been assisting with getting travel documents and sort of anything else they may need to do for ICE to execute the removal order. We've unfortunately seen many people still in detention after the 180 days. We're talking people who have been in detention for a year or longer after a final order of removal. And the federal courts don't necessarily review habeas corpus petitions very quickly. So this is not a hard and fast rule. At 180 days, ICE is going to wisen up and let you out. And even if you're fighting this case, it could potentially take a very long time to get released. We did receive some good news yesterday where one of our clients who is COVID vulnerable and was denied release on the 5th of January, today, with our help, was able to get a grant for his release. And we are hoping that he will be released, if not today, tomorrow. So the administration has issued a notice of proposed rulemaking. To date, it has not gone into force, saying that employment authorization documents should not be provided to individuals on orders of supervision, except in certain limited circumstances. And we've written a public comment in opposition to that we would encourage people to take a look at. But basically, it appears, due to the timing of things, that the administration was not able to issue a final rule before Biden will take office in a few hours. So, the administration has the option of withdrawing that proposed rule from consideration. The rule's bad enough that it's probably not worth trying to modify it and still put something forward. And they could sit on it, but then of course that would run the risk that a future administration would pick it up where Trump left off and continue on. And of course Congress would come in and directly write into statute that individuals on orders of supervision are authorized or can be authorized to work in the United States, right? There's still certain, an application that they have to fill out and other requirements. So in terms of ICE policy, a couple of important points. They have broad discretion. They don't really need to detain people, right? Even when it comes to ICE raid or picking someone up from criminal custody, somebody who would be in mandatory detention, they don't need to make that arrest initially. They certainly can release people at processing at the CBP level before they even get into an ICE detention facility. This is what the Trump administration was calling a catch and release program. Number one, this was not happening to a lot of people. I mean, we had the highest detention numbers in history at over 50,000. It was hovering around 52,000. I think it might have touched 55 at one point, but very high numbers. People were being picked up and placed in detention centers. And, this sort of implies that the person is being sort of caught for something bad, which asylum seekers are, typically have not done anything bad. And then that they're sort of being released to just go wreak havoc in the United States. But they're being released so that instead of the U.S. taxpayer, footing the bill for a detention bed, they can stay with their family or their friends while their case is processed. So that really is the best option. We would suggest the administration also look at shelters in the sense of government-funded shelters. Of course, the grants could be given to existing shelters to expand or for new ones to open up. So these wouldn't be ORR facilities or really modeled on an ORR facility. They wouldn't be a family detention type holding place, right? These would be shelters where people would be free to come and go, right? They would be run by, independent parties, not by the federal government, but they would have staff that could support people in their case processing. It could have attorneys on staff as well as social workers, similar to a lot of the migrant shelters around the country, and similar to the discontinued case management program that was so successful at helping people get to their court hearings. Basically, at the end of the day, what we need in ICE decision making is clear standards. We've seen people with the exact same documents be denied or released simply based on who their officer was. So there's not consistency in decision making. On the flip side, sometimes there's too much consistency, right? The individual cases are not looked at carefully. So everybody will be given the exact same bond amount regardless of their ability to pay. And, other factors that may be relevant won't necessarily be taken into consideration. ICE decision making is not transparent. It's not clear how they reach the decisions they make. They have very little accountability, at least to the public and to the immigrant community. They, potentially have accountability to their supervisor within ICE, but there's no appeal process. You can submit a second petition for release, but that petition isn't going to receive the same result unless you have something significantly different to say. So the only quote unquote appeal process is if the person has the right to appear before an immigration judge for a bond hearing. And there are three types of decisions that we've seen from ICE. One is the no decision, right? So ICE basically de facto makes the decision to continue to detain the person, and they never inform anyone, right? They won't inform the attorney. They won't inform the individual. They basically just sit on the case. Obviously problematic, right? Not a sign of good governance. Second, there's a form letter. It's a one-page letter. It fills up half a page of that, and it basically says we reviewed everything you submitted, and we've decided to deny. Okay, no explanation of why. Zero. Right? Template language. The third type of denial is a form with checkboxes, and the officer will check the box, for example, for a flight risk, but they won't provide any explanation for how they reached that conclusion. Right? So it's up to the individual to guess. Now, when the individual has an attorney who's familiar with practicing at that detention center or follows up, they may be able to get an idea of why that person was denied. Or if they talk directly to the officer, they probably will hear. I've been told by ICE officers, oh, your client has a court date coming up, so we're not going to release them. Not a factor to the release determination, right? It's identity, stable place to live, danger to the community, flight risk. Not how soon their hearing's coming up. They also sometimes will deny cases in a recent case, for example, where the individual did not have extra COVID risk factors. It's like, yes, but you can still release people. You needed to release people before COVID was a thing. Those same release policies apply. COVID risk factor is an additional reason to release someone. It's not a reason where you would take away someone's ability to be released. So we see all sorts of things happen, but one of the things that has been positive is several courts at various local district court levels, no sort of nationwide injunction on this, but a couple of courts have come out and said that the burden of proof to show that someone's a danger to the community and a flight risk rests with DHS. Right? It's the government's burden to prove, not the respondents. And that has really shifted the dialogue, at least in those courts. So we'd like to conclude this first section of the podcast by encouraging you to sign our petition to grant bond hearings to arriving alien asylum seekers in statute. Write your own petition on any of these topics or others. And get your friends and family to sign that and share it. Contact your elected representatives, and of course, publish as much about these issues as possible through the traditional media or through social media. Beyond health concerns, there are many other problems with doing a case in our immigration court system from inside detention. First of all, it's very difficult to access evidence. The ability to gather evidence is dependent on the person's financial situation. In other words, their ability to make multiple phone calls to relatives and friends living abroad. It is dependent on the phone system, because to call out and have your call accepted, the person you're calling has to press 1 to accept the call. And sometimes that automated message is in a language the person does not speak and understand. There also has to be an individual in home country who's willing and able to gather evidence. For example, a birth certificate may not be released to someone who is not an immediate relative. The individual may also be, for some reason, unable to obtain evidence because, for example, recently during COVID, buses have stopped operating in certain countries, and travel has been restricted by official ordinance. It is also difficult to get access to health professionals, whether those are mental health professionals or other doctors who can do an examination and prepare a letter explaining what that person's injuries and current situation is. So for example, forensic evidence demonstrating that the person's scars correlate and are reflective of the type of harm that they're reporting in their declaration. That a psychologist can evaluate an individual's current state of being and determine whether or not they are suffering some form of mental illness as a result of the torture that they faced in their home countries. Secondly, access to counsel is incredibly problematic from inside a detention center. These detention facilities can often be a significant drive for counsel. For the Migrant Center, for example, it takes us 2 hours round trip to visit an individual at the Pearsall Detention Complex. So it's not realistic for us to travel to deliver a paper, to get a signature, or to otherwise have a 15-minute meeting. The rate of obtaining counsel for individuals in detention is about 33%, whereas individuals outside detention obtain counsel about 66% of the time. For asylum cases, your chances of winning and receiving protection are 5 times higher if you're represented. So the fact that an individual in detention cannot obtain an attorney as easily has a very real and significant impact on their ability to receive protection in the United States. Even when someone is lucky enough to obtain an attorney, so either they pay for one or they find one of the few pro bono attorneys available, the frequency of their meetings with that attorney are likely to be less than for someone who is outside detention. One of the reasons for this is that law firms will often send paralegals to conduct the meetings and may only come to meet with their client to prepare for the final court hearing. Sometimes this is also due to the fact that the detention center, due to low meeting space, will have situations where individuals need to wait for up to 5 hours to get in to see one person. And I can say from personal experience, by the time that you've been waiting in a detention lobby for 5 hours, when you get into that first meeting and you have another 9 people you're seeing after that, you're tired. You're already in a position where you cannot perform at optimal ability. And it is very important that we have a lot of energy and high attention to the conversations that we're conducting with people at the facility. So a lot of attorneys just simply don't want to go. They don't want to deal with the travel time. They don't want to deal with the wait time. They don't want to deal with the stress of being in a detention facility. And sometimes that includes the stress of working with someone who is under a lot of stress themselves. So the stress impact on individuals, as well as the health significance of this, it has a direct correlation to their ability to do well in court, to their ability to obtain counsel, their ability to focus in court, right? They're not likely to get a good night's sleep at the facility. They're not likely to get a good meal. All the things that we normally counsel clients to do to be prepared for their hearing. The stress on the attorneys, for those who say, well, I'm going to make the trip and I'm going to help people as much as I can. And, if I hear a horrible story of torture, I'm going to go on a jog when I get home and decompress, and I'll figure out what sort of stress management tools I need to employ. Eventually, these attorneys are going to get burned out. In the vast majority of cases, the retention rate for attorneys doing detained work, at least in the nonprofit sector, is fairly low. If you look at the staff attorney population, you're going to see about 50 to 60% of those attorneys having anywhere between maybe a year or 2 years on the job. And so this means that the attorneys with the most experience, not only the most knowledge in the law, but also with the most practical experience on how to navigate a court case, are not going to be available to hire for people in detention. There's also a significant problem with access to technology. So many detention facilities, including ours, don't allow computers to be brought in, so unless you get special permission. So you're needing to take handwritten notes and then take that back to the office, type it up, realize you had something you need to fix, go back, ask for clarification. Some of that's naturally going to happen just in the course of an interview process, but it can be challenging to not have access to a computer. And additionally, access to technology. So there's not the ability to go onto the internet and quickly and look up something that an individual is talking about. So if they say, I posted this on Facebook, or I talked to the media and they wrote an article about me in this protest, you can't go back and immediately check that and confirm that and make sure that you're finding what you need to. And it's sometimes not easy to do that from the office because you may not have the keyword search terms due to language differences, a different spelling of names, etc. So how do we fix these problems? First, the administration should, through the Department of Justice, EOIR, immigration courts, continue to support pro bonos in offering them access to courtroom space for meetings. And we would ask that the administration also expand the use of courtrooms to nonprofit organizations that want to conduct Know Your Rights presentations or otherwise provide legal consultations free of charge to people, not just to individuals who are represented and whose case file is already registered with the court as being the legal representation for the hearing. Support a legal orientation program and other pro se support programs. Provide counsel to low-income respondents and expand representation of those with limited capacity. So that includes individuals who would fall outside of matter of MAM, which looks at the competency of someone to stand trial. So that's mostly mental health, but also consider other competency issues such as where individuals may be illiterate and aren't simply capable of filling out applications for relief, and really sort of the administration can sit down with stakeholders and say, what are all the issues that you've been seeing, and let's see how we can address those. So one thing that can be done, short of providing representation for every person going through proceedings, as is true in the criminal process, right? Everyone has the right to public defender, is to translate forms into other languages and then to accept those forms back in those languages. And of course, they'd have to be translated again. So this would certainly be an undertaking, but really would ensure that people are not being discriminated against due to the country they're from and the language they speak. To have equality under the law in our system, we really do need the ability for people to communicate. So they have the right to an interpreter currently in court, but for all the court procedures they have to do where they're not physically in the court, such as fill out their application for asylum, they are left on their own. This creates a lot of delays as they need to request continuances to try to find pro bono assistance. And in some cases where that doesn't happen, makes it incredibly difficult for the judge to review whatever halfway filled out form they'll get by by some friend that they've met in detention that speaks their language maybe 20%. The administration can also look at providing interpreters for pro bono programs outside of the LOP context, so that any pro bono cases and any pro bono Know Your Rights presentations or consultations can have the support specifically in third languages. So those are also called maybe rare languages that are not necessarily third languages or rare languages, but that are not widely spoken in the United States, right? So it can be very hard to find interpreters or people to volunteer in those languages. And that can also slow down the process once someone has found an organization that's willing to help. The next thing that is important is to reinstitute the relationship between the Board of Immigration Appeals and the Clinic Pro Bono Project so that the pro bono attorneys that are placed with cases can have access to the full record. So that's not just the transcript that's been typed up of what happened in court, but also a copy of the evidence. And that relationship was ended under the Trump administration for no clear reason and really should be instituted. It's very hard to represent someone if you don't have a copy of all the documents that were submitted into evidence. It may seem silly that that even happened, but it did. So that's where we are at. We also believe that it's important for Congress to step in and set a detention bed quota attorney room situation where the statute would say if this facility has 100 beds, then they must have one room for an attorney. Right now at the Pearsall Detention Center, there's one room for every 450 people, approximately. So even if half of those people have attorneys, or more likely the case at 1/3, if their attorneys only come to meet with them once a week, there is still not near enough space for those meetings to take place. And that's why we have the long wait times at the facility. It's important also to provide confidential televideo. We don't really have access to confidential phone calls, much less televideo, and it can be very important to observe and respond to body language. In fact, many studies have shown that the vast majority of the way that we communicate is not verbally, it's through our body language. And we miss that when we do our meetings because of the COVID situation. Most of our meetings now are by phone. We miss out on things. And the individuals that are working with us, it's harder to build the trust that's required because it's harder for them to get to know us, right? And at a minimum, we need to be able to have confidential phone calls. So the Migrant Center has joined a local stakeholders letter to our San Antonio field office asking for access during COVID so that we can continue to represent people effectively and zealously and in line with our ethical duties. And we have to date not heard back from them in response to that. So we provided a few resources to you on this right-hand side of the slide that may be of interest in further understanding the issues presented here. Expedited removal is the statute that basically says a person does not have the right to a court hearing if they were picked up within 14 days of crossing and within 100 miles of the border. The statute actually allows the administration to expand expedited removal, and the Trump administration attempted to do that but never really instituted it into policy practice on the ground, fortunately. So the Trump administration had basically gone to the outer limit of statutory authorization, saying that any time an individual is picked up within 2 years of entering the U.S. and anywhere in the country could be placed in expedited removal without the right to see a judge. Expansion is problematic because of the difficulty of proving someone's been in the United States 2 years and certainly getting together that evidence under an expedited removal timeline. So if you're picked up and put in the ER pipeline, you're talking about potentially several days in the case of a Mexican. In the case of someone from Central America, potentially a week or two before you're shipped off. The only exception to this is if you claim fear of return, in which case you would be going through a screening interview that would determine whether or not you'd have the right to speak with a judge about your case. So the other problem with this system is that individuals who are not asylum eligible or don't want to put forward a claim for asylum. So this is individuals who might have a cancellation of removal case for being in the United States for a while, or and so this would be probably more likely like a VAWA cancellation, because if you had the 10 years and you can prove it, you wouldn't be placed in expedited removal. But if you couldn't come up with that proof, of course, then we could be deporting someone within a couple days who's been here for over 10 years and has qualifying family members and no criminal history to speak of. So there's a real problem with our system, more broadly speaking, with the judges not being allowed to hear certain types of immigration cases, and USCIS processing those too slowly. Also, the reverse is true with USCIS not having the authorization to hear certain types of cases, right? So a person has to basically present themselves for deportation before they can get certain types of protection and immigration status in our country. Makes no sense. And we'll talk about that a little bit more at our podcast on Friday. But basically, Congress needs to step in and revise the statute. There's no reason that expedited removal should apply to people anywhere in the country. There's no reason that it should be for people who have been here for 2 years, right? 1 year. And in fact, it would be good to use this opportunity to look at whether or not we need to have an expedited removal process, period. Our position at the Migrant Center is that at a minimum, the administration should create, and when we say administration, in this case, it would be Congress, right? So Biden can do a lot of this by executive action in terms of what he decides to implement and how he wants to interpret the statute with regards to, where there is that wiggle room. But again, 4 years, we could have another president. It could change it back to the where we've been under the Trump administration. So really, it's much better if Congress steps in and gets things on the book in the law. And so basically, at a minimum, we should have a law that says if you have a legal pathway to come out of the shadows and regularize your status, whether that's asylum or another pathway to legal status, you should be able to take that case before an immigration judge. Certainly if the immigration judge has authority, and we would argue that the judge's authority should be expanded to what types of cases they can hear. For example, they should be able to hear the cases of crime victims. They certainly can do so already for individuals of domestic violence, but they can't do so for individuals who qualify for U or T visas. And there's no reason that couldn't be expanded. So these are all some things that, to our knowledge, are not included in the Biden proposal, while it has not been made public yet. And so some of the provisions have not leaked their way out into the press. The priorities of that piece of legislation don't address this area of the law at all. So we will be reviewing tomorrow the legislation and coming to you all with an analysis of that in more detail. The other point of action that needs to be taken, and this specifically is in the executive branch. Okay, so this is not an area where Congress can really step in at all, or would we want that to happen necessarily, right? This is the prosecutorial discretion, right? So this is the ability of the prosecutor to decide what is a priority case, right? So under the Obama administration, at least in theory, the policy was to deport people with criminal history. Okay, Trump did away with that. He says you're here without documents, you're out. And so it wasn't that the Obama administration wasn't deporting people who had no criminal history or very minor criminal history, right? But they were more actively going after people who had more serious crimes. And the Trump administration, has sort of cast a broader net But there's been what's called collateral arrests regardless, and tomorrow we'll be discussing interior enforcement. So prosecutorial discretion ended under the Trump administration. It was the policy to basically just deport everyone that could be deported. And the word on the street, right, the policies within the agencies was, don't grant. Just don't grant. But this is, it ended sort of, because individuals within the administration, would still make decisions based on their judgment, and some of those decisions would still be favorable. But we definitely experienced a narrowing of the space for negotiation and for collaboration, frankly, with the government to reach the just and legal outcome in our cases. So prosecutorial discretion exists within Customs and Border Patrol and within ICE with regards to who's going to be detained, who's going to be released, what are the factors that are looked at, right? Because you do want to have some criteria so that you have a fair system. And then in the more traditional sense, the ICE Office of Chief Counsel, where the trial attorneys, the government prosecutors sit. They, before Trump came into office, would sometimes agree to grants of asylum. We'd walk into court. They would say, I've reviewed everything. I don't need to hear testimony. This person's eligible, right? So under the administration, and that saves everyone time, right? Specifically the court system, which is overburdened, with 1,300,000 cases at last count. So this really allowed the government lawyers who have a duty of candor to the tribunal as legal representatives of the U.S. government. And as representatives, when we say of the U.S. government, we're not talking about representatives of, President Trump. We're talking about representatives of you and I as American taxpayers. These are the attorneys that are there to uphold our values, but more importantly, those values as written in the U.S. Constitution and in our laws. And so, attorneys really should be agreeing to grants of protection. They, should be joining in motions to reopen, motions for continuances, for termination, motions to reconsider, when the person is eligible, when that makes sense for the quick and fair administration of justice. They can certainly say they don't oppose a motion. This is kind of one of the ways they've sort of gotten around things a little bit. And so, we'll write a motion to the judge and we'll say, well, we've spoken with the opposing counsel and they don't oppose this motion, right? So they're not formally joining it, but they don't oppose it. The important thing about having DHS join motions is that sometimes is the only way of getting around time limitations. But without getting into the technical weeds of it all, the bottom line is that there needs to be a flexibility within the system so that individuals within the government can respond to the case in front of them, right? So they can sit down with us and say, yes, we think a $2,000 bond is reasonable, right? They don't always have to try to get the $10,000 bond. And so, we really need prosecutorial discretion to come back in a major way. Of course, that should be with guidelines and trainings to ensure that there is no, real extreme differentiation on how people are treated. We do want to make sure there's, equal treatment before the law. But this is something that will potentially be very helpful in practice, right? Some of the bigger policies that have been discussed by the Biden administration's transition team are, of crucial importance. But sometimes it's the small day-to-day ability of people looking at cases to make decisions that is going to have a really big impact. And so we did talk in our asylum podcast about the discretion of immigration judges to make decisions and how that's been restricted and limited, and we need to change that. That podcast is available on this YouTube channel if you would like to tune into that. But across the board, this is an area that where really, the tone can be changed and set from day one. And few memos written up, organizational culture can change. And I'm certainly not saying overnight, but it can change significantly enough to help people in practice with more or less a stroke of a pen. In addition to some of the advocacy ideas that we mentioned earlier today, we have provided here a link to a template letter to Congress on detention oversight, and also encourage you to consider what we think is a fairly creative strategy to approach this issue, and that's to reach out to your local health department and ask them to find out how they're communicating with the detention centers, and ask them to conduct surprise investigations, right? To prepare public reports, and engage really in a conversation with them. There is a requirement that ICE works with the local health departments, and so this is an avenue that can be explored more by advocates. And we've included a link here to a detention medical conditions toolkit that hopefully will be of assistance to folks. With that, we conclude our podcast. Please do tune in on Thursday at 8:30 for our discussion on interior enforcement, as well as Friday's podcast on affirmative benefits. So those are benefits that people seek legal status through USCIS. And feel free to reach out to us if you have any questions or would like to sign up for our newsletter. You can also access more news and analysis at our website, job postings and volunteer opportunities, as well as learn more about the work of the Migrant Center for Human Rights. Thank you again for tuning in today, and have a wonderful day.